Good afternoon, everyone, or good morning, everyone, wherever you're located. Welcome to our Digital Service Act Bite-Size webinar series, part 5 of 5, last part today on enforcement. Thank you for taking the time. And as we only have 30 minutes, and we absolutely want to keep those, so we don't keep you away from any other commitments, let's start right away. This is the other content we have. You may have listened in on other instances of our webinar series on the DSA, so feel free to check our web addresses. It's going to be on the last slide. Please go there and check out the other content if you haven't done so already, and we'll also follow up. And as you've heard just now, we're being recorded here, and it's us presenters, none of you is audible or visible, so no privacy concerns at all, and all ready for you after the webinar to take in again if you'd like. We are hosts, and I'd like to hand over to Adi, my Dutch colleague. Please, can you tell us who you are, Adi?
Yes, thank you, Thorsten. Well, hello, everybody. My name is Adi van Nieuwenhuizen, and I'm working at the Field Fisher office in the Netherlands. We're based in Amsterdam, and I'm specialized in tech, data protection, and also soft IP. So back to Thorsten.
Thanks, Adi. My name is Thorsten Ihler. And thank you also for taking the job of pronouncing your name. Adi, I know I don't have the most of international last names, so please just refer to me as Thorsten if you'd like to get in touch. And I'm also specialized in privacy and data protection and tech matters. And we'd like to go on with the content, which is this. So we're going to do a short recap, really very brief, on what the DSA scope is. So just you're aware, because I can imagine you're probably either of two types listening in, buckets of people interested in the DSA. Either you already know that you'll be caught in scope of the DSA and you need to plan, even if it's probably a while off, perhaps even years from the timeline that we anticipate. But you still would probably need to do a lot if you're not one of the very largest providers and doing a lot already. And the other potential attendee might be just out of interest, curiosity on what's happening in the digital sphere on EU policy making and the legal obligations that come with it. After that, we're going into the juicy stuff here on enforcement. Adi is going to lead that right away. And then we're switching roles on bringing to you the content of regulating actually and enforcing the DSA. And after that, to try to get away a bit from the purely academic hypothetical, because the DSA hasn't been finalized yet, not issued, we're trying to give ideas of what might happen, how enforcement might play out in terms of mechanisms and regulators. And for that, we're going to look to the Dutch and German markets. What's already there? What do we see? What kind of legal measures can you take? What's happening from a regulatory perspective? And at the very end, we'd be happy to take your questions. If you have any, please use the chat functionality and we'd be happy to pick that up. All right. Ideally, at the very end, you'd take away a couple of learnings. So getting an idea, this overview of what I've just said, the regulators, the regulatory mechanisms that would probably be in place once the DSA is here, understand the regulators' powers, enforcement competencies, and in the end, as I said, draw parallels, perhaps to existing enforcement of online regulations. We'll give a few examples there from the Netherlands and Germany. This is, I don't expect you to read this. We're not going to go through this, don't worry. This is actually content I've taken from this URL you see at the bottom. It's from the European Commission itself. You see here the kinds of service providers at the top as headings of the columns. So sort of, if you want to think of it as concentric circles, getting bigger and bigger by the type of service or services you're providing to end users. And on the left-hand side, it's the kind of obligations you have to satisfy. So however big you are, if you are the smallest intermediary service, you have to do something. And if you're a very large online provider, you have to do a lot more. That's the scope. That's the first question you should ask yourself. And there's lots of material on our webinar series on these points, on scope and actual obligations you might have. All right, that's it from me for now. And Adi, I'd like to hand over to you again.
Yes, thank you, Thorsten. Yeah, I'm going to talk you through the first chapter, and after chapter 3 of the DSA, and that's mainly about the sanctions, the bodies, and the cooperation. And with this DSA, the European Commission is introducing the digital service coordinators, the DSCs, and these are regulators at member state levels, and these regulators will be responsible for the application and enforcement of the DSA. And the DSA oversees service providers who have their headquarters in a specific country, and that's a concept we already know from the GDPR. And this means that for many major tech players, and especially the very large platforms, we will speak about it more in detail later, the Irish regulator might be the main regulator for unless they switch their headquarters to another member state. And a regulator will have far-reaching possibilities to investigate, for example, the operation of the notice and takedown and action mechanisms, or the application, for example, of algorithms by the platforms. And the digital service coordinator can issue fines up to 6% of the annual turnover if there are structural and deliberate violations of the procedural rules of the Digital Services Act. And the choice of these national regulators is remarkable because there is already a lot of criticism within the GDPR of now especially the actions of the Irish regulator. Within the EU, we have seen that this is a bottleneck for many investigations into these major tech players. And it also raises questions about how to deal with physical local problems through platforms based in another EU member state. So can we go to the next slide, Thorsten, please? Yes, so if we look a little bit more closer into this chapter 4, section 1, we see that the articles 38 to 46, they are about this DSC, so the competent authorities and national digital service coordinators. And so the thing is that there should be the establishment of one or more competent authorities in the member states, and they will be responsible, what I already mentioned, for the enforcement of this regulation. And so one of the authorities, it's not clear if it's already a member state can choose if they would like to use an existing authority to serve as coordinator, or that they will create a new one. And this coordinator will cooperate with the other DSAs, with other national authorities, and even across borders with the board and the Commission. And the coordinator shall be completely independent, and it should act in an impartial, transparent, and timely manner. And it can also form joint investigations. So all these requirements are included in the different articles. Can we then go to the next slide? So the jurisdiction, that's what I already mentioned in the introduction. The member state in which the main establishment of the provider of the intermediary services is located will have the main jurisdiction. However, if there is not an establishment in the EU, however, there is the provider is offering services under the jurisdiction of member state where their legal representative is established, then that member state will have the jurisdiction. And if everything falls outside, then they can provide a legal representative in one of the jurisdictions. So then all member states could have jurisdiction. So those are the 3 requirements. Can we go to the next one? So the DSSA, the Digital Service Coordinator, will have a lot of different powers. So they have a lot of force. They have first, we can start with the besides of the enforcement and to impose fines, they have investigation powers. They have the power to require providers and other persons that may be aware of information relating to an infringement to provide them information. And they have the power to carry out on-site inspections, so they can go to premises of the providers. They have the power to ask members of the providers or other persons who are related to an investigation to interview them and to record the answers. They have the enforcement powers, so they have the power to accept binding commitments. They have the power to impose fines. They have the power to impose a periodic penalty. And they also have a power to order a cessation of infringement and to impose remedies. They can also, there's also power against providers of intermediary services. And finally, all the measures taken by the DSC must be effective, dissuasive, and proportionate. So it's quite a list what they can do. Yeah, and then that's always important, the penalties and a little bit the complaints. Well, the penalties, as you already know, they can up to be 6% of the annual income or turnover. And the DSA can also impose a periodic penalty payment, and that can be up to 5% of the average daily turnover. And recipient of the services, they have the right to lodge a complaint against providers of the intermediary services alleging an infringement of the regulation at the local DSA. So it's the penalties, it can be quite high if you are if you will get a fine by the digital services coordinator. And then
indeed quite high. It almost seems like someone wanted to top GDPR fines. Speaking of GDPR, here's something else that's slightly familiar. A board, the European Board for Digital Services, it's currently called in the draft DSA, and perhaps akin to the EDPB under the GDPR, it has an advisory role. It's called an independent advisory group for the DSCs, and it will advise the DSCs and the European Commission. And what I've set out here in bold print is perhaps quite interesting. It is supposed to ensure consistent application of the Digital Services Act, so that sounds promising. I have a small but on one of the next slides, but at least the mechanism is here. It's supposed to harmonize application in the European Union. And it's going to give other kinds of guidance that then should be followed by the DSCs. And it's going to play a role in the supervision of very large online providers. And it's going to be made up by representatives of the DSCs. And those representatives will have one vote each. And the Commission will chair this board, but it won't have a vote. So the Commission has the chair seat, and as you can see on the bottom here, it will also support this board, which means I get from the general layout that the board can become quite powerful. If it gets support on the administrative side from the Commission, it might be resourceful, but we'll have to see how that plays out and when it's going to be set up under the final DSA. They're going to take majority decisions, so nothing with absolute unanimous decisions. Then I guess that might lead to controversial decisions in practice. Again, looking to the GDPR, EDPB, where not everything seems to be unanimous. And also they can invite experts and cooperate with other EU bodies. So there's a full breadth of possibilities of what they can or are supposed to do really. We'll have to see how much they can really tackle, who's going to be on it, and how often they meet, and what they can really move in practice. And the one small but I mentioned just now is on the very bottom right here. To me, it seems that there's no strict coherence going to be on the board, or let's say an application of the DSA, because the law expressly says that there can be DSCs not following the board position, and they just need to give reasons, is what the law says. So, which means to a lawyer that they can indeed head another way. Just need to explain it. This is perhaps a pity, but again, we'll have to see how this plays out. And we're already used to not so strict harmonization on the GDPR. Lots of familiar topics here, I think. There's a couple of other points here, and the general idea is going to be that they're going to give guidance to DSCs. That's the idea. All right, I'm going to hand over again to Adi for section 3 of chapter 4.
Yes, thank you, Thorsten. Yeah, section 3, it's about the supervision of the very large online platforms, the so-called VLOPs. And the introduction of these very large platforms category is another notable point from the proposal. And just to remind you, these are platforms that have more than 45 million users in the EU, or 10% of the number of EU residents. And this category includes a very select group of platforms. Most of the social media platforms will often occur. And these very large platforms have many more obligations regarding content moderation, procedural rules, and transparency. And in addition, they are obliged to have an audit every year. And the European Commission says it considers this proportional because these platforms are large enough to bear extra responsibilities, especially financially, and because the impact of these platforms on matters such as disinformation is really huge, is enormous. It works as follows. The DSC of the establishment, if they adopt a decision finding that a very large platform has infringed any of the provisions of the DSA, and then they must use the supervision system, and that's included in Article 50 of the proposal. And in this, the digital services coordinator must take into account the opinion and the recommendation of the Commission and the board. And that's what Thorsten already mentioned, that the Commission and the board will have like a huge impact and influence. And then there's a kind of follow-up system. There will be an action plan how to stop the infringement. There have to be a view whether or not the infringement has terminated or remedied. And then the Commission can initiate proceedings in view of the possible adoption of decisions. And then they can proceed if there was not any further investigation or enforcement measures. And the DSC can also request the Commission to intervene. And then can we go to the next slide, please? And also in this case, not well, a little bit like the coordinator, the Commission has several powers against these very large platforms. They have the on-site inspections. They can also request for informations. They have the right to interview. Interim measures they can order. They can make a commitment binding on the FLOP and monitor the effective implementation and compliance. And they can, of course, impose a fine up to 6% of the global annual turnover, and again the periodic penalty payments up to 5% of the average daily turnover. And they can also ordering the platform to provide access and explanations in relating to the databases and the algorithms the online platforms are using. So the Commission has quite a lot of power. Back to you, Thorsten.
Thanks, Adi. So at the very end of this chapter 4 of the DSA, there's a couple of, actually really a couple, 2 articles on common provisions. And there's 2 possibly interesting points. Article 67 is going to establish an information sharing system. It's more of an administrative point, but still, I think the goal, which seems perhaps likely to be achieved, is better information sharing. And we've heard, again, drawing a parallel to GDPR, that it took the regulators a while from the member states and also the EDPB to set up a mechanism that allows them to collaborate. And maybe this experience has found its way into DSA here. And so this is in the law, directly express letter of the law, that there's going to be an information sharing system. So again, we'll have to see how it works technologically and communicationally, but it's all there. And then at the very end of chapter 4, there might be something looming which we don't have in all of the member states of the European Union. And that's something I've boldly called class action here. Don't slay me if I get this wrong under your local laws, and there's no such thing as class action. But the point is there, at least for these 3 articles, 17, 18, 19, certain rights of the users, there is a clear mandate, or let's say the possibility for a mandate, that they can turn to not-for-profits and ask them to take in mass claims, you know, on a large scale, and then see them through in the courts. So this is phrased in a broad way, and it'll be exciting to see whether this actually happens. And also, as if it were planned and the lawmaker had helped us here, I'm now going to turn over back to Adi, who on our last bit of the webinar is going to tell us a bit of enforcement in the Netherlands. And I believe there have actually been cases, prominent cases of things I call here class action. Adi, please take over again.
Yes, thanks. Thank you, Thorsten. Yes, that's correct. We have a new class action. Well, we already had a class action act, a law, but now it's we have a new one. I can give a separate webinar about that. But in this new class action articles, participants can really get money back from an infringement. So we've seen now a couple of class actions that are now filed with the court with respect to the infringement of the GDPR, but it's also on other subjects. So that's now I immediately go to the last point. Yeah, court proceedings, those are possible in the Netherlands. Yeah, people can go to court. It either can be like these class action vehicles they are acting on behalf of data subjects or individuals or consumers. However, the supervising authorities, for example, the Authority for Consumer Markets, but also the Dutch Data Protection Authority, called the Autoriteit Persoonsgegevens, well, they can go to court as well, but they can also impose, they have their own measures, their own enforcement powers. So they can start investigations. They can impose fines when there is a breach. They have a lot of power. So we think that either one of these authorities will be the DSC. However, as the Dutch Data Protection Authority is already really has a lack of people and really a lack of budget, maybe it would be strange if they will be the DSC as well, because then they're really too busy and they do not. Well, now at this moment they're already really behind everything with all the complaints. They are 6 months behind the complaints of data subjects. So maybe it will be the role for the Authority for Consumer and Markets. They are both doing competition law issues, but also telecom, e-commerce. So I think maybe it will be more for this authority, but it's not sure. So maybe there will be a new authority. Well, we have to see it. It will depend. Also depends on the new government we will have. So back to you, Thorsten, for the final 4 minutes.
Yeah, thanks, Adi. So I'm just going to pick up briefly maybe 1 or 2 points here. So it's going to be interesting. I fully agree which authority is going to be the regulator here for the DSA. I personally am sort of excited to see what that's going to be with competition law authorities, enforcement bodies. They're huge. They've existed for decades. They have lots of experience in hitting large providers, and we are already seeing this in several member states, including Germany, France, for instance, where the cartel officers or antitrust regulators are trying to hit online providers. So that will be interesting, whether they take the role in some of the member states as a DSA regulator. And speaking of regulators, I'm not sure whether you may be aware, but in Germany, we have lots of regulators that dabble in these areas like consumer protection, data protection, competition law. And sometimes they're not even real regulators. Like in consumer protection, we don't have a formal regulator, whereas in data protection, we have 18 that are specifically there for enforcing GDPR and other data protection provisions in all of Germany. And other regulators are trying to dabble in as well. So that's a conglomerate really of interests and parties there. That is, can be an advantage, can be a disadvantage, depending on which side you are. But for consistency, certainly it's not the best interest of everybody. And also to agree with Adi from the Dutch perspective, there can be all sorts of measures, really, the full breadth of measures under administrative law, court proceedings, out of court proceedings, everything. And also the platform, of course, can try to enforce the law itself, perhaps under its terms and conditions. That's going to be interesting, whether that's really going to be the gatekeeper role here for DSA. Thank you so much for giving us your time, for listening in. And as I said in the beginning, we promised to keep to the 30 minutes. And here we are, just short of them. I don't see any questions on chat. So unless someone brings any question up now, unless Adi, you have anything else to say in the end, I'd say that's it from us. Thanks again for listening in. And we'd love to see you on our websites and perhaps recommend our series of webinars and maybe come back in half a year's time when we have more clarity on how and when the DSA is going to be implemented. Thanks very much.
Thank you.